Hi guys, welcome to another episode of Atty. Vlogger, Law for the Everyday Layman. Today we'll take up part 13 on the law of sales and we'll talk about legal redemption. Now if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Now, legal redemption is a special mode of extinguishing a contract of sale. And by legal redemption, we understand it to be the right where one is subrogated on the same terms and conditions as stipulated in the contract to the place of a person who acquires a thing by purchase, dation in payment, or any other transaction where ownership is transferred by onerous title. Okay? Now, this right of legal redemption applies whether the thing is movable or immovable, but it must be exercised within 30 days from receipt of the written notice by the seller of the sale to a third person. Okay? Now, as to the form of exercising the right of legal redemption, tender is not required, no? It is sufficient that a mere offer to redeem has been given and the law does not require a certain form. Okay? So it can be a formal tender of payment and consignation, or it can be an informal offer to redeem. Okay? However, this will not be recorded in the registry of property unless the seller makes an affidavit attesting to the fact that he gave written notice to all possible redemptioners. This is to protect the rights of all those persons who may want to redeem and are allowed to by the law. Okay? Now, this right of legal redemption is a mere statutory privilege. Okay? And it is based on public policy for the benefit and convenience of the redemptioner and also to minimize co-ownership. If you will remember in my previous discussions, the law does not favor co-ownership because the interests of one co-owner is subject to the desires of the majority, which will necessarily lead to conflicts in management, and it will discourage the improvement or cultivation of the property. Okay? So as much as possible, the law would want to put an end to the co-ownership either through partition or consolidation or in one of the co-owners or in a third person. Okay? Now, the right of legal redemption will not apply to donation, to succession, to barter, mortgage, or lease. Okay? And we have to distinguish legal redemption from conventional redemption, which we discussed in the previous video. Because in conventional redemption, which is sale with right of repurchase or a pacto de retro sale, that right to repurchase must be expressly reserved in the same contract of sale at its perfection. While legal redemption does not have to be expressly reserved, and it can apply not only to sales but also to any other transaction where ownership is transferred by onerous title. In case of conventional redemption or sale with right to repurchase, it is the seller a retro who exercises the right to repurchase the thing. Whereas in legal redemption, it is exercised by a third person who is not a party to the sale. Okay? And finally, in case of conventional redemption where the property is redeemed, then the contract of sale is extinguished. While in legal redemption, there is a new contract which substitutes the original contract of sale. Okay? Now we can talk about the instances of legal redemption, no? And we begin with Article 1620 of the Civil Code. Under this article, legal redemption may be availed of by any one of the co-owners or some of them in case any one of their fellow co-owners or some or even all of the others, all of the others, I emphasize others, okay, sell their undivided share or shares to a third person. In case two or more co-owners wish to redeem, then they may only do so with respect to their own respective shares. Okay? So in order for this article to apply, of course, first there must be a co-ownership. Second, there must be an alienation of the share of any of the other co-owners or even all of the other co-owners. I keep mentioning other because it should not be an alienation of the whole thing, okay? All other co-owners, meaning there is one person, usually the redemptioner, who has not alienated his share yet, okay? Third requisite, the alienation must be to a third person who is not a co-owner, okay? And finally, the alienation must be before the property has been partitioned, okay? And in order for the right of legal redemption to be exercised, it is required that written notice be given by the selling co-owner to his fellow co-owners that a sale has been made to a third person, okay? And in case that sale to that third person was for a price that is grossly excessive, then the redeeming co-owner can pay a reasonable price to redeem it, no? He can pay lower than the grossly excessive price, okay? Now, the right of legal redemption under this article will not apply in case of a sale from one co-owner to another co-owner, because the sale here under this article must be a sale to a third person, okay? This right of legal redemption under this article will also not apply if the thing has already been partitioned. Again, remember, the sale of the share must be of an undivided immovable. So there should be no partition yet. This article will also not apply in case the shares of all of the co-owners have been sold, okay? As I kept emphasizing earlier, there must be at least one of the co-owners or two, no? At least one who has not sold his share and who wishes to redeem the property, okay? And finally, this article will not apply in case the thing itself has been offered for sale by all the co-owners, okay? Now we can move on to the second instance of legal redemption, which is under Article 1621. And 1621 refers to sale of rural lands, okay? The rural land here must not exceed 1 hectare, and the sale must affect adjoining owners, okay? So the requisites for this article to apply are as follows, no? First, both lands involved are rural lands, okay? Second, those rural lands must be adjacent, okay, or beside each other or in front of each other, no? Next is that one of those lands must be alienated, okay? And then the next requisite is that the rural land which is alienated must not exceed 1 hectare, okay? The next requisite is that the buyer of the rural land which does not exceed 1 hectare must also already own other rural lands. And finally, the lands must not be separated by brooks, ravines, roads, or any other apparent servitude. Okay? Now, what if the land which is, the rural land which is sold has several properties surrounding it, meaning there are several adjoining rural lands. And all those owners, or two or more of those owners of rural lands, want to redeem this sold land, no? To whom will preference be given? The law says that preference will be given to the adjoining owner who has the smallest area of land. Okay, so let's say XYZ want to redeem the land sold by A. If X has the smallest area of land, then he is the one entitled to redeem. But if X, Y, and Z in that same example have lands of the same area, to whom is preference granted? Then preference will be granted to the person who first requests for redemption. Okay, first in time, priority in right. Okay, and the purpose of this whole article on allowing redemption of rural lands is to encourage the maximum development, cultivation, or improvement of the rural lands, no? So that the adjoining owner can now have a bigger contiguous land within which to devote the purpose of to devote the lands to its purpose, no? Such as farming or agriculture. Okay, so that's the purpose, no? So now we can move on to the next instance of legal redemption, which is provided for under Article 1622 of the Civil Code, which refers to urban lands. And under Article 1622, there are two rights involved. We have the right of preemption and we have the right of redemption. When we talk about preemption, this is a right to be able to purchase the land before any other. Okay? In other words, it is exercised before there is a perfected sale. And since it's exercised before there is a perfected sale, then there can be no rescission of the sale since there's no sale yet. Okay? And the action for preemption will be brought against the prospective seller or the person who wants to sell the land to another. But when we talk about the right of redemption, this can only be exercised after there has been a perfected sale. Since there's already a perfected sale, then that sale can also be subject of rescission. And the action for redemption can be brought against, in this case, the buyer. In preemption, you bring the action for preemption against the prospective seller or the person who wants to sell the land. In right of redemption, you redeem from the buyer, the person who has bought the land. Okay? Now, in order for either preemption or redemption to apply, these are the requisites. Okay? First, of course, the lands involved must be urban lands. Okay? Second, wait. So how do we know if the land is urban? No, we will know the land is urban if the community or the surrounding establishments are likewise urban. Okay, so that's the first requisite. The lands must be urban. Second, the lands must be adjacent. Okay, there must be an owner of adjacent land. Next, the land must be so small and so situated that a major portion thereof cannot be used for any practical purpose within a reasonable time. Okay? Next is, or fourth is that the property was bought, okay? Was bought before merely for speculation. And finally, the land is about to be resold or there is a resale, no? It has been sold to a third person and that resale has already been perfected. Okay? Now, what if in this, as in the case of rural lands, what if this urban land has several adjoining owners? Okay? To whom will preference be given? Okay? The law just says that preference will be given to the owner of the adjoining land whose intended use is seems or appears to be best justified under the circumstances. The purpose of this whole article, no, is to discourage speculation in real estate, especially since in urban areas like in Metro Manila, no, there are housing problems. So it's to prevent the aggravation of housing problems in urban areas. Okay, so what's an example of this legal redemption in urban lands? No, so let's say X has a house, no, and the X finds out that part of her house is so happens to be or encroach on the land of another. Okay, or Y, when Y decides to or thinks about selling, okay, their land, then X has the right to preempt the sale and be the purchaser, or in case Y has already sold it, to redeem that portion of land because her interests appear to be the best justified. Why? Because you do not want to demolish that part of the land which has encroached supposedly on the land which was sold. Okay? So that's to maintain her ownership over the land. Okay, so that's of course assuming that Y purchased the land for speculation and the presence of all the other requisites. Okay, so those are the instances of legal redemption which are provided for under the law on sales. However, there are other instances of legal redemption which are provided for by law. One example would be in the case of assignment of credits, no, under Article 1634, no. So legal redemption exists in favor of the debtor in case of a sale or assignment of credit or other incorporeal right which is in litigation. I'll talk about that more in my next video, okay, on assignment of credits and other incorporeal rights. So, another instance of legal redemption will be found in Article 1088 of the Civil Code, in which case, if any or all of the co-heirs in case of succession, no? In case a person has died, no? If any or all the co-heirs in case of a sale by one of or all of the other co-heirs of their hereditary rights. Okay? It's similar to the article in 1620, except that in this case, it's co-heirs and the subject matter is hereditary rights, no? In case one of or any of the co-heirs sell their hereditary rights, then the other co-heir or co-heirs have the right to redeem the hereditary rights which have been sold within 1 month from written notice of the sale to a third person. Take note, however, what is being sold is the hereditary right. It does not apply if what was sold is a particular property. Okay? So, another instance of legal redemption exists in the case of sale of a homestead or free patent, in which case the applicant, his wife, or his heirs can redeem that land under a homestead or free patent within 5 years from the purchase. Okay? We also have the redemption in case of execution sales by the judgment debtor within 1 year. No? We also have the equity of redemption or 90 days from equity of redemption in case of foreclosure of real estate mortgage. Okay, 90 days from the final judgment or confirmation of the sale. And we also have the right of redemption in case of extrajudicial foreclosure of real estate mortgage. Equity of redemption, yung 90 days, that's judicial foreclosure, to make it easy. Okay? But right of redemption, yung 1 year period, that's for extrajudicial foreclosure. And that 1 year period is counted from the date of registration of the certificate of sale. Okay? So that's it for legal redemption. I hope you have picked up a thing or two, and that concludes my series for the law on sales. However, I will be uploading an episode on assignment of credit, and I will include it in the playlist of the law of sales. Okay? So, I hope to see you soon. Bye!